President Trump taps Budget Director Mick Mulvaney to temporarily head the Consumer Financial Protection Bureau. And the White House says it's up to the president. He has the right to do that, name an interim leader. But outgoing Director Richard Cordray promoted Leandra English to acting director on Friday. Now English has filed a lawsuit saying Trump's appointment is unlawful. The White House says English is still the deputy director under acting director Mulvaney. So does Leandra English have a case? Here to discuss, Fox News senior judicial analyst Judge Andrew Napolitano. Judge, this thing is crazy. I just never knew that someone in an agency could tell the president of the United States, hey, you have no authority over us. It's like a rogue agency.
This is the most unique agency in all the government, because all the other agencies, if Congress doesn't like the way they're doing their job, they can give them more money to do a better job, or they can give them less money to if they don't like the job they're doing. This agency is paid by the Federal Reserve. It's not paid by Congress. It is the only entity in all of the government that has governmental power and is not paid by Congress. Congress can't control it. So one of the arguments that Mrs. English's lawyers will make is that Congress intended for this to be. And I'll tell you why. Here's two statutes conflicting. Right. The president relies on a 1998 statute which says when there's a vacancy in an administrative agency, the president replaces the person temporarily until a nominee is confirmed by the Senate. There's another statute, the one that created this, Dodd-Frank, which is 2010, 12 years later, which says when there's a vacancy in the office of director at the CFPB, the deputy director becomes the acting director. So we got two statutes clashing. What do the courts do when two statutes disagree? They generally accept the more recent one, the theory being Congress was aware of the old statute when it wrote the new one, and it wanted to disregard it for this agency and this agency alone.
That's a dangerous path to go down.
Yes, it is.
You start to supersede rules that have been established for a very long period of time. If you have a majority, the House, the Senate, and the White House. I mean, you can actually do that. Perhaps someone could argue that this was intentionally created in such a way that a Republican president could not.
That is the argument that Mrs. English's lawyers will make, and they will make it probably around midnight tonight when the government's briefs are due. It's unfolding as we speak. They will argue that they wouldn't call it rogue, as you and I might, and a lot of people watching us might, and as the president has. They will say this is a unique agency intended to be immune from the very political pressure that Donald Trump is putting on it. The president will say, hey, wait a minute. This is a democracy. How can there be something in the government that nobody can control, that fosters and furthers and reinvents itself? That's what the courts are going to decide. It really goes to the heart of representative government.
So this is the ultimate form of obstructionism. This was, you can argue, it was a brilliant move on the last administration to obstruct. Really, though, in a way, they're obstructing the will of the people, though, aren't they?
Well, it was
President Trump won this election with an electoral college landslide.
Yes, you could make that argument, and what you say is true. The lawyers for Mrs. English will say, and now you're getting amicus briefs filed by Speaker Pelosi and God have mercy on me, former Speaker Pelosi and Minority Leader Schumer saying this is what the Congress intended.
Let me ask you real quick, because the Carpenter versus the United States is coming up perhaps this week at the Supreme Court. This is huge, huge news. It's going to be all over the newspapers on Wednesday and Thursday, no matter what the decision is.
In every, I'm holding up my iPhone, in every cell phone, there's a computer chip. And the computer chip records where the cell phone is. The police downloaded the wireless transmissions of the location of a cell phone without a search warrant, and it showed that a burglar was, in fact, casing a joint that he was convicted of robbing, because the court admitted that evidence in. So the Supreme Court now has to decide, can the police do this without a warrant? If they can do this without a warrant, then nothing is safe. Your medical records, your legal records, your banking records, your browsing habits can all be downloaded by the police on a whim without any suspicion whatsoever. And as we know, there are good people in government and there are not so good people.
Carpenter versus U.S. Judge, you bring a unique and great view of all this stuff. Appreciate it. Thank you very much.
Pleasure, Charles. Pleasure to be with you.